USCIS has a new trick up its sleeve, and you better be careful. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. Yesterday, I received an email from an immigration lawyer in Texas. This lawyer wanted my opinion on what he should do on a case that he had. This is a relatively straightforward marriage-based green card case. So, here at Hacking Immigration Law, we handle immigration cases all over, and we handle marriage cases a lot. Other than suing the government, it's one of our main things that we do. And so he wanted to know about this notice of intent to deny that his clients had received. And there were a couple of interesting things about this NOID. This NOID is what we call it. In the NOID, USCIS pointed out that the couple had not submitted a lot of evidence. And when I read over the notice of intent to deny, I was surprised by the fact that it had been issued before the interview. So in other words, this couple had filed an I-130 and an I-45 packet. They filed for the work card and the travel document and everything. And the notice of intent to deny had been issued by the local field office. And in the NOID, they were saying basically, you don't have enough marital evidence to allow this case to go forward. Our intention is to deny this case. And this is our notice to you of the intention that we have to say no on your green card application. And that is without the interview. So this is really interesting because I know many, many, many cases that have been approved after the couple brings a lot of evidence to the interview itself. So in an effort to decrease their backlog, it appears that USCIS has made the decision to have people have their cases assessed before they come in for an interview. So this suggests to me that there's a new level of scrutiny at the beginning. And the fact that the notice of intent to deny was issued without a request for evidence tells me that they're leaning towards denial in these cases. And so this is a real watershed moment. This is a really big thing in immigration. We haven't seen this before. And this is a trick that you need to be careful about. And what it means is that you need to file a strong case at the beginning. No longer can you just wing it. Can you just slap together some bank statements and a couple pictures and mail it in and hope that it gets approved? This proves my point that I say all the time on the Immigration Answers live show and on these videos, which is you have to file the strongest case possible at the beginning, because now they are looking at it, they're screening it, and if they don't think you're worthy, you don't get to see an interviewing officer. It makes sort of a lot of sense in a way. I mean, I always think that USCIS is up to something, and they often are. But in this one, I have to give it to them. I mean, if you don't meet a certain threshold, then why should the officer waste their time interviewing you? The other thing that was interesting was that this notice of intent to deny was issued without a request for evidence. Usually, a request for evidence comes first, and then they tell you that they want to deny it. So they're definitely getting more aggressive. They're definitely pushing back. I would imagine, I don't know for sure, that this person who applied has not received their employment authorization document, their work card, and it's probably sitting while this notice of intent is responded to. The attorney wanted to know my advice. The attorney wanted to know, Jim, would you refile the case or would you file more evidence? And I said, here's what I would do. I would bring that couple into my office and I would scare the shit out of them. I would pound on them to say, look, your case is on life support, friends. There's something seriously wrong with this case. You didn't give us enough evidence to give to the government, and the government's pushing back. So you need to get your act together, and we need to develop a whole lot more evidence. So I said I would treat it as a new filing, but I would keep my place in line by responding to the notice of intent to deny. The case is still approvable. They can still win. But they're going to have to do a whole lot more work, and this attorney's going to have to do a whole lot more work. So in my mind, I said we would be treating it as if we're starting over, like from scratch, like the evidence that we sent before was no good or insufficient, and now we really need to build a case. We need to get affidavits from family members. We need to get affidavits from neighbors. We need to develop evidence, not just mail in a couple documents and call it a day. So that's what I would do. I've offered to help this couple to see if they need our help, and he's going to take it to them to see. I don't know if this is a full-time immigration attorney or a part-time immigration attorney, but I was happy that he reached out. I'm always happy to talk to my fellow colleagues in the immigration bar. We have that old saying, the enemy of my enemy is my friend, and it all works many different ways, but we're all on the same side, so I'm always happy to help other immigration attorneys. And I hope that they are able to help their client and get that case approved. But the lesson for everybody is that you really need to make sure that you are filing that strong case at the very beginning so that you don't receive a notice of intent to deny, because not only does it put the case in peril, but they're also going to lose 2 or 3 months while they're developing evidence to support the case in response to the notice of intent to deny, which is why it's always better get all that stuff up at the beginning so you're not scrambling with the hard deadline from USCIS. Hope this all makes sense. Hope you found it valuable. We will see you next time. Now, if you want to get a hold of us and hire us to help you with your marriage-based case or any kind of immigration case, give us a call, 314-961-8200. Now, don't be calling our office just to ask for free advice. If you want free advice, come on my Immigration Answers show. You can find it on our YouTube channel, which you should subscribe to, and you can find it in our Facebook group, which is called Immigrant Home. So the purpose of calling our firm is to hire the firm or to consider hiring the firm or to find out more details about hiring the firm. It's not just to get free information. We put out more free content, I think, pound for pound than any other immigration law firm in the country, and I really encourage you to use it. You avail yourself of it. Educate yourself, learn everything you can about the immigration process. But if you want top quality, high level immigration representation, that's when you call 314-961-8200. That's when you email us info@hackingimmigrationlaw.com. Thanks so much, and we'll see you next time.